after a week, it is not counted by, now we wanted to mention.
Right. Wait, please, Your Lordship, I'm praying for listing of a alien petition on 8, Your Lordship. Your Lordship, matter is fixed before trial court on 9th, Your Lordship.
Let it be on 7th.
Keep your Your Lordship.
7th.
Daily list, motion, item 1.
Medical report and preliminary.
Not received. Oh, first,
Medical report and.
yes. Art learned councils. Call for CD. And medical report.
Right. Separate, yes.
List on. This is coming from
Separate.
Khetri. You can come sometime next week, 13,
Right.
13, 14,
14, right.
14.
14.
14.
16, okay. Maybe 16,
16th.
16.
16.
Right.
Item 2.
The case petitioner on call for CD
Again, medical report.
and medical report. Fixed on 16th.
Right. 16. Right.
3.
I pray that scan copy of the case may be provided with the remote person.
Charge sheet 5.
All have been granted by except this petition. He said, all have been granted by except this petition, but because the case has been charted, we have moved here at the design. Just a scan copy of the document, examine the matter.
Art learned councils. Call for scan copy of the LCR,
Right.
including the CD. From which court?
It's more leadership. Moving of this case.
You have to give the case number. Court of CJM.
Yes.
Is it CJM?
Well, here is CGM.
Or SDJM?
CGM.
CGM going.
CGM.
CJM Bongaigaon. In connection with the case pending before CJM Bongaigaon in connection with Bongaigaon police case number 51 of
Yes.
2023 under section 302. 101. Okay. List after receipt of scan copy is also.
4.
And in this project, Polycom case version under section 498-302. It's suicide. Other issues were already granted.
Where is the FIR?
Case 14.
11 to 14 worship.
Who are the petitioners?
Petitioner is the husband worship.
Call for CD. In connection with NPM report in connection with Morigan PS case number 170. 170
Yes,
of 2023. List on 19th. CD and PM.
5.
FIR is page number 8.
Yes.
With due respect, it is to be stated that on 18/5/2023, night at about 11 o'clock, through a source information, the officer in charge of the police station get information that one Abdul Karim, son of late Akil Ali of Village Yusmari, had been doing the business of fake currency at his residence. Accordingly, a DDNT was made and directed me by the OC and the car. He has to take appropriate. As that I along with staff proceeded to the house of Abdul Karim at Usmari village and in presence of witness doing search at the house of Abdul Karim. After about an hour of search, we recovered 76 number 500 recovered 500 currency notes from under the bed and seized the same in presence of witnesses as mentioned in the figure. Thereafter, the said suspected fake currency was taken into the police station. It is to be mentioned that there is a big candy involved with Abdul Karim and Abdul Karim was not available at his residence. This FIR is on 19/5/2022. Lord, back on 120. Police arrested so many people when they are out of line in connection with the state.
Let us have a look at the,
Recovered from the petitioner from
let CDB call along with FSL report. Yes, for FSL report.
Look at currency.
This was CD and FSL report.
Yes,
Call fixed on 19.
not.
On motion item 6,
Yes, Mr. Rahim.
You have filed this petition, but working out posting. Even the FIR was filed by the sister-in-law. FIR is 13.
Yes,
This 13 melon. There is the attempt of 376 melon as per allegation of the FIR. And therefore matter was settled between them. And she denied melon, she refused medical test. And next melon test. 17 melon.
yes,
And in the meantime, it has been submitted, all the matter was settled, and he has had another affidavit is 30.
Hmm. Yes,
It's an important matter. Paragraph 4, 5 matter. It's 31.
Hmm.
Regarding the principle of Honorable Supreme Court judgment given by the. At least the lot may mission occasion.
some dispute was there. What is the dispute?
She was deserted wife, my lord, and husband driving around. I give him shelter at my land. Now she refused to vacate. This is a family dispute.
Yes, madam.
Article 376, that is not compounded deduction, but it also be called for the scan copy of LCL, what we should go to the one deduction.
Heard learned councils. This
6 case has been brought by the office given this
criminal petition is filed by the petitioner seeking enforcement of the charge sheet number 390 dated 29/11/2021, as well as the impugned order dated 21/2/2022, passed by the Court of CJM Bolketa in PRC case number 21 of 2022, under section so and so, arising out of Bolketa Road PS case number 480 of 2021, as well as the entire proceedings of PRC case number 21 of 2022. Where learned counsel for the petitioner submits that although an FIR, where is the FIR? FIR dated 2009/2021 was lodged by the informant, alleging that the petitioner had trespassed into her house and tried to commit rape. However, because of the hue and cry raised, people in the neighborhood gathered and she was saved from the accused. Full stop. Learned counsel with the petitioner submits that this allegation is completely false and concocted. He has referred to, also he has referred to an agreement, affidavit stated to have been sworn the informant, where it is stated that the FIR was filed as a due to mistake of fact and on ill advice of some rival person. And the matter was amicably settled between the parties outside court. Learned counsel for the petitioner has referred to the judgments of the apex court rendered in Narinder Singh and others reported in so and so, as well as Kapil Gupta and others reported in so and so, to submit that in a matter where the parties have settled the dispute outside court, the competent court ought not to have taken cognizance. And in the event of any such cognizance being taken, in spite of the fact being brought before the competent court, that matter was settled outside court, then the High Court should pass necessary orders, setting aside and interfering with such orders, taking cognizance and proceeding in the matter. MS SH Bora Learned APP submits that the scanned copies of the case record be called for. Accordingly, let notice be issued returnable 4 weeks. Let the registry call for the scanned copy of PRC case number 21 of 2022, pending before Court of CJM Bolketa. That's the case number?
21,
Yes,
29.
21.
Order.
Also, let notice on respondent number 2 be served through registered post 80. Since Learned APP has already entered appearance on behalf of respondent number 1, no fresh notice be issued. However, extra copies be furnished within the period of 1 week from today. Also, till the next returnable day proceedings in respect of PRC case 21 21/22, pending before the Court of CJM Bolketa, shall remain stayed. Placed again on so and so date. After 4 weeks. It will be in August, 7th August. 7th August.
Item 7,
I have several start shaking and going to the car. Then you have this start in.
Let us first see the FIR, yes.
There are 33 number of issues in the name of
Hmm.
when they are kind of this will be very
Hmm. Yes, clear.
and the submission is there. 2 years ago, the informant parcels a block of land measuring 5 biggest 11 the top Goremari. Near the factor number 24, that number 31 and needed in her name and the state upon constructing out. In the state land, the image of the informant reside along with the image of her brother-in-law Abdul Golim by constructing out. Since then, the above name accused person namely, namely Yasin Ali, Tazen Ali, Mahmoud Ali, Jahangir Ali, Haveduddin, Umbid Ali, Mir Muhammad Ali, Hikmat Ali, Jalaluddin, Zahidul Islam, Rufsan Ali, Lamsa Mia, Rustam Ali, and Zafar Ali have been trying to follow the appropriate plot of land. They pretend to kill the husband of the informant, Sultan. The villagers spoke openly that they will kill Sultan. In this regard, last from 28 to 2021, the informant lost a complaint under section 107 against the above named accused person. That is case number 364-21 dated 28 of 2021. After that, the accused persons were disturbed in various ways. The informant and her family members to puzzle for that. Last on 9/10/2021 at about 7:30 AM, the above named accused persons are going to get together, trespass into the campus of the informant by breaking fencing of timber. At that time, the informant was talking with her husband, Sultan Ali, brother-in-law Abdul Golim, and Zoinal Abidin. The mother of the informant, Rezia Khatun, from Ilyas Ali, and sister-in-law Aziram Nessa were cutting wood at yard nearby. After entering into the campus of the informant, the accused Abia Khatun poured water mixed with chili powder on the eyes of Sultan Ali, and Sultan Ali at once fell down on the ground, and then the accused Amzad Ali, specifically Amzad Ali, Zafar Ali, Zahir Ali, Awal, son of Sultan Ali, Jalaluddin assaulted Sultan Ali with bamboo lathi on his shoulder and on the backside of it with an axe. As a result, his brain comes out, and at once Sultan Ali died on the spot. The informant and her family raised hue and cry. Thereafter, accused Havel, Sahidul Islam, Tahir Ali, Kohar Ali, Zahidul Islam, Zafar Ali assaulted with dagger on the head of the brother-in-law of the informant, Abdul Jalil, and then assaulted on the eyes with dagger. As a result, Abdul Jalil has died on the spot at once. After that, all the accused persons assaulted both the deceased person with lathi. Thereafter, they assaulted the brother of the deceased person, Zainal Abdul, on his head, hands, and legs with lathi. Then Zainal Abidin and other family members somehow managed to flee away and save their lives. Accused Tahir Ali is not away when moved to latter part. There is no specific name written to those who are assaulted the deceased. But I will assign them also last person 30 to lawsuit. This there is no whisper in the lawsuit apparatus. And in the Sashi, I have this from the and during the investigation, I have been never start.
Let us call for the scan copy.
Okay, along with the CV.
Did you not appear before the court?
No.
Why?
So the APM to 9 to be.
Ah,
So the APM to watching my name to be in the past.
so you filed a revision petition. So you want to file a revision petition
No,
praying for stay.
no,
Had learned counsel for the parties in his message for amendment for the stay. This criminal petition is filed by the petitioner so and so, praying for caution of the charge sheet number 1043 dated 12/10/2022, submitted under so and so. In PRC case number 1371 of 2022 under section so and so. which is presently pending before court of CJM court. It is submitted by the learned counsel for the petitioner that the petitioner is named in the FIR at serial number 32. However, the informant never made any allegations specifically in the body of the FIR. His name was never referred to. So it is further submitted that during investigation, he was never called by the investigating officer in respect of the LS offences. However, in the charge sheet submitted, he was shown as an absconder. Learned counsel for the petitioner submits that he is no way connected with the offences alleged. Therefore, there is no occasion for the IO to submit charge sheet showing him as an accused, nor for the court to have taken cognizance in the matter. Charges have been framed. Accordingly, let notice be issued. When is the next date?
26. 26.
Let CDB call for. Scan copy of the LCR in connection with PRC case number so and so from Borbeta, CJ in Borbeta we call from. List again on 22nd June. Steps by registered post on. Respondent 2 within 1 week from today and extra copies on Learned APP appearing for respondent 1 within a course of 1 week from today.
8.
Yes, Mr. Mojumdar.
Notice this petition is for quashing the FIR, but we will find this FIR as another day.
Yes.
Notice this
Hmm.
FIR is registered under section E66 and section E28 of the IPC, but the basic components to constitute the offense under these sections are absent in this FIR. Most of this section E20 is about the holding hard by means of poison. That is, if someone administers poison to someone with the intention to commit offense, only then this section will come out. But in the FIR, no such disclosure is made. And in fact, the section P76, the FIR itself will disclose that no force is applied. The FIR in big plot says that I borrowed an amount of 50,000 from the informant. Thereafter, I had conspired not to refund the amount. I conspired along with my wife not to refund the amount. And one day I met the informant. I made her drink some intoxicated cold drinks. Thereafter, taking situation, I had a physical relation with her and took some options photograph. Thereafter, I started blackmailing. And my wife inspired me to do this crime. But it is not at all believable that a housewife, Indian housewife, will inspire her husband to rape someone with the intention to blackmail. And no specific date is given when the incident took place. In the FIR, as per the FIR, the incident took place in the year of 2022, and it is filed almost after 1 year. The real story is that, Lordship, the informant is the agent of a Manipur-based laundry agency, and I've invested some amount to the agent, but she did not deposit the amount which I had invested to her. When I came to know about the scam, I claimed to refund, I claimed to get back my money. Thereafter,
not to refund my money. He dramatized the situation by way of filing the FIR. In fact, Lordship, though no case is made out under section 376 and under section 328. This FIR is filed with a ulterior motive. In fact, no commission will disclose, reading of the FIR will disclose that no commission of offense has committed under section 376.
You are on bail now.
Yes, Lordship.
You are on bail.
Yeah.
Matter is still under investigation.
Charge sheet yet to be filed, yes, still under investigation.
Heard. Mr. Swain, learned counsels for the parties, MSSH, for our learned APP for the state. This criminal petition is filed by the petitioner. Petitioners, how many petitioners? Two, one petition.
One petition.
Praying for quashing of the FIR. Registered as Silchar PS case number 2666 of 2022 under section 2 and so. Post of learned counsel for the petition submits that the allegations made in the FIR are totally unbelievable, concocted and false. Post of it is submitted that the petitioner invested some money in some scheme through the informant. However, the said amount was not handed over by the informant, and consequently when the petitioner demanded the money to be returned, the FIR dated so and so was filed, making absurd allegations against the petitioner. Let notice the issue, returnable after 4 weeks. Since state is represented by MSSH for notices are waived, or the extra copies be furnished within a period of 1 week from today. Let steps on respondent number 2 be taken by registered post within 1 week from today. It is submitted that the matter is still in the investigation, no charge sheet has been filed. It is after 4 weeks. We'll consider your praise on a later date.
Item 9.
Fixes the date of.
Let him take the steps, it will come. Why fix it? We're not calling for any CD.
Scan copy called for it.
We have not called for CD.
Not.
You obtain instructions, show us, we'll find out.
Item 9.
Make legal logic. This is question of fire logic, petitioner peculiar logic, the forest and officer logic. During the discharging of his duties, he has seized and apprehended a bolero truck with full loaded showing timber logic. Thereafter, this FIR has been filed with the personal charge against this officer logic. FIR logic, cancellation portion, page number 21. 21. And regular portion is 24. May I read the cancellation portion?
Yes,
Yes, but I have honored to state that I am wife of the driver of Bolero pickup bearing registration number so and so. On dated so and so, my husband so and so went to her booth under the Onga. The forest ran diploma party took the vehicle along with goods to Itapula Forest office. After loading the goods, and the accused demanded to be so and so for compromise, and later on fee of rupees 70,000 and paid rupees 54 only, and for remaining 16,000 paid to our mobile. Then he returned the mobile handset. While returning the mobile, the accused took my mobile number and he informed me time to time over the telephone that he would sleep with him for 2 nights. He closed the case and gave the demand later. I apprehended him
him red-handed to prove the incident in presence of the witnesses at Dolabari. I have kept all recording of the hacking in this is the allegation against me, Lordship, and accordingly, initially this case has been registered initially before the Kespu police station, and accordingly he has been provided an arrested. And thereafter, due to the want of the lack of jurisdiction, case has been transferred to the Sotia police station, Lordship, and accordingly, Sotia police station has been registered a case, Lordship. This is the allegation, Lordship. And this is totally false and baseless allegation against due to the personal does this lady lost this FIR, Lordship. Your Lordship find this six documents, Lordship, annexer E, page number 33, Lordship. Yes, Lordship. This is the forest offense, Lordship. Accordingly, the vehicle has been apprehended and seized, Lordship. Page number 33, page number 34, Lordship.
There is no dispute that the vehicle has been seen, is mentioned in the
There is
FIR.
no dispute, Lordship.
The
Yes,
dispute is with the allegation made against you.
yes, Lordship. But as per my instance, so this is all these are the personal
We'll
grievances.
see about that.
Yes,
Learned counsel
are Lordship.
for the parties. Yesterday petition is filed by petitioner seeking enforcement of the FIR dated 28/8/2022, which is registered as well as the Sukia, as well as the PS police station case, which is registered as Sukia PS case number 71 of 2022 under section so and so and so. Where a learned counsel for the petitioner submits that the petitioner is a forest official, and in the course of his duties, he had seized a Bolero vehicle along with sawn timber. Also, the petitioner had proceeded in the matter as per the provisions of some forest regulation 18 so and so. And against the petitioner, against the driver and the persons involved in respect of the safe forest offences. Most of them. Thereafter, by the impugned FIR dated so and so, the wife of the driver made the absurd allegation against the petitioner. Also, learned counsel to the petitioner submits that he has seized the vehicle in course of his official duties, and only in order to coerce him and force him to release or the vehicle or prevent him from proceeding under the provisions of the forest regulation. The FIR has been filed by the wife of the driver. Yeah. Learned APP, IPS for the state, prays for time to obtain the required instruction. Let notice be issued, returnable 4 weeks. Since learned APP has already entered appearance, no notices are need to be issued to respondent 1. However, sufficient extra copies will be furnished within a period of 1 week. Steps on respondent number 2 by registered post AD. It is after 4 weeks.
Give your best.
Item 10,
Wait this alone. Your 438 allegation, madam. FIR is page number 10. But the allegation in the FIR is that madam, the petitioner and the informant were involved in a relationship, madam. But subsequently, madam, due to objection from the informant's family, their marriage could not be consummated, madam. And the informant was married to one Anisul Rahman, madam. But their relationship, madam, still continued, madam, and they used to meet often, madam. Now, on this given day, madam, these people did a petition and the informant, madam, were apprehended by the neighbors and also minority applicants family, madam. And due to public pressure, madam, the informant was compelled to lodge this FIR against the petitioner. Ma'am. Now, my lord, the allegation in the FIR is that, my lord, the said accused person has developed a physical relationship with me on the pretext of marrying me, my lord. My lord, why would, my lord, the petitioner had to give a false promise of marriage, my lord, in the pretext of developing a relationship with the informant when it is admitted position that they were already involved in a relationship, my lord. And the next allegation is that when my family members came to know, they tried to perform marriage with the accused person, but the said accused person refused to marry me, and that's how come, my lord, if petitioner can marry the informant while she is already married to one person, my lord? Obviously, she will obtain divorce with this person, my lord. Well, this is totally a false and baseless affair, my lord, which was lodged, my lord, due to public pressure, my lord. So at this stage, my lord, the interim may be considered.
Yes,
Everybody says a better judgment. It's essentially better judgment, because there's a very very.
heard that it comes to the parties. Yes. Maybe petition is filed by the petitioner apprehending arrest in connection with an FIR dated 7/3/2023 lodged by the informant one. Sana Begum. I don't give the name by the informant. They say the FIR was received and registered as Moripur PS case number 151 of 2023 under section swing suspense. Here are learned counsel for the petitioner submits that the bare perusal of the FIR, it is apparent that the petitioner and the informant were in a relationship earlier. As such, the further allegations made that the petitioner had made a false promise to the informant, offering her marriage, is not acceptable in view of the fact that the petitioner, the informant had herself stated that she was married to another person. There are let CDB call for. No medical is necessary here.
Medical, perhaps I got to,
CT along with medical report we call for,
and 164 strip.
as well as 160 statement. In the meantime, if the petitioner is arrested, he shall be released on furnishing a bail bond of rupees 13,000 with one local security like amount to the satisfaction of the arresting authority, subject to the following conditions. Will appear within 1 week from today before the concerned IO should not leave the jurisdiction. The IO will complete.
7th of August. sir.
9th of August.
Item 11.
Here, please. The informant's daughter got married with the affair with case number 1. After marriage, she committed suicide. The father of the business called the affair against both family members. The petitioner, people will see father-in-law and mother-in-law. And the son, after marriage, he was staying in separate house. At that particular night, what happened? The present petitioner is not here. In fact, the present petitioner also stated his son is out of control and he was a research writer. And the marriage was summarized of his own. And they have eloped and from the marriage. The present petitioner, they are in separate house and the fact they are not there. That is the case.
No, mere statement saying that they are in a separate house. Where are they residing?
Yes. I will stated that
Where is your son and former daughter-in-law, late
Page
daughter-in-law?
5 minutes.
Page 5.
Page 5, paragraph 7 minutes. The first paragraph, last 3 lines. After marriage, they started their continual life in a separate house.
Separate means where? What address? Which place?
But address is not so different. The house is only.
So how do the same compound, different house?
But
What difference does it make?
The present petitioner never interfered the conjugal life.
That is for the investigation to find out initially. Merely saying living in a separate house.
That means that Just clear the point.
No, but you can't be lead spectators to tortures put in by your son.
And actually, what happened, everything with the son.
No, all right, your son, you can't abandon it and saying he got married on his own.
That the son is out of control, because there is a subnational without the consent of both family members. If you law and affection, there's some measure marriage. The measure for
Yes, madam.
So actually, whatever there is specific allegation against the accused persons, yes, all of them put together also.
Hmm, all of them.
This is some of the Rafipa Norman budget, Kudukia Koni. I being separate Batakon. So all the allegations against all the accused persons. Fortunately, at this stage, call for the case study and the case for the
We'll consider it after going through the case diary. Serious allegation.
in the affair they have mentioned, but in fact she committed suicide. It will come in the case diary.
Then the case diary we call for art so and so, then counsel.
Suspect actually they have lost.
Let CDB call for along with PM reports. We'll consider after upon going through.
It will be case of 306, I think, because
Could be.
commitment to commit suicide. Sometimes perhaps will be a small-
Let it be listed on 22nd,
on 15th of June.
15th.
Yes.
Along with medical, CD, sorry, PM report.
Item 12,
Possible funding acquired on page. Basically, the page 10, basically, allegation regarding fine imposed for overloading.
Overloading.
Overloading, cement losses getting overloading, there was charge for 50,000 was there, and for the life hazard losses, 5,000 additional fine was there. Total 55,000 rupees fine imposed against the truck losses. And therefore, whatever logic that nowadays logic that the online payment is the option is also there logic that they after the conversion of the truck owner logic, we say that logic the fine has been already
No.
the online logic.
Who is the informant?
Inform the DTO officer,
DTO officer.
employee of the division. Enforcement inspector.
And who is the accused?
Accused is the caretaker of the truck logic. He was there at that point of time. Also. When the fine was imposed, okay, there was talk with the officer on duty. Okay, I have categorically made the statement that the fine has been paid online, and the officer also let us to come. Okay, and thereafter, this FIR has been filed maybe due to pressure of higher official. It is made a case for it, and 382 does not attract the allegation.
What are the sections?
Sections are given. 353 will attract lordship as per the allegation, but 382 does not attract.
Deterring public
There
service
is,
from discharging his duty.
there will be their lordship as per the allegation, but 382 lordship does not attract. Ingredients are not present with that.
Are other counsels to the party?
And one more thing, lordship, the fine has already been paid, so they're not any extra. They're on page, on page 70.
AB petition is filed by the petitioner. Praying for anticipatory bail, apprehending years. In connection with an FIR dated 27/5/23. Lodged by the informant who is an enforcement officer under the Department of Transport, Department of Assam. So the FIR was received and registered as Sonapur case number 90 of 23 under section so and so and so. It is submitted by the learned counsel for the petitioner that the petitioner is the what? Is the caretaker of the
And he
vehicle
was present in the trial.
bearing registration number A01 so and so, which was carrying about 40 metric tons of cement. Also, he was present in the truck. the counsel for the petitioner submits that there was some altercation with the informant, but ultimately the fine which was imposed was paid.
Case 7.
A copy of the receipt is enclosed as Annexure 3, page 17 to the payable petition posted. The learned counsel to the petitioner submits, however, that submits that the further allegation that he had threatened the staff and obstructed the government officers from doing his duty is totally incorrect. Accordingly, he is apprehending arrest, he is filed the bail petition. There are let MS SH Boral and the PP submits that let CDB. Only CD is required,
Only serious.
CD for at this stage. Accordingly, let CD be called for. In the meantime, if the petitioner is arrested, he shall be released upon furnishing a bail bond of ₹30,000 with one local security of like amount to the satisfaction of the arresting party is subject to the following conditions. He shall appear into the IU within 10 days from today. And he shall not attempt to influence any person or witness or move out of the police station. Which police station is this?
Punapur.
Punapur PS, without written permission. Is a resident where?
He is a resident of Lordship Forces Club.
Then you will obtain written permission from the IU for moving out of the jurisdiction of Punapur PS. Based on 9th of August.
Much of it. Much of it.
13.
The logic was not everything important, I find it very stable.
Yes. Yeah, read the FIR.
It was simple accident case noted.
Yeah.
And now the education is under section 302 and 34. The petitioner number 1 is the wife of the deceased, 2 is the brother-in-law, and 3 is the mother-in-law.
How is it simple? The person has died.
Nothing.
There is a death.
No, nothing like it. We had a very good relationship. Petitioner
No, somebody died.
died.
So you still want to say it is a simple case of accident? Somebody died,
Nothing, it is a simple accident case.
but somebody died.
Yes.
Then
The petitioner number 1 is the wife of the informant. We are married for last 23 years.
Wife of whom?
Wife of the deceased.
Wife of the deceased.
Lord.
And who has filed the FIR? Who is the informant?
Informant is my petition number one mother-in-law, the deceased mother.
Mother. Yes, madam, what do you say?
Lordship, otherwise, prior to the incident, that was on 10/5/2023. As per the allegation, Lordship, the accused number one injured the son of the informant, Lordship, the deceased. Lordship, may at least take for the case study along with the postmortem report. It is an accident case, so it is a plan that we do not know at this stage. And Lordship, in the second para, it is to be noted that my son will get more than 1 crore money for his service. Just for the sake of living FIR.
Heard learned counsels for the parties. This, the petition is filed by the petitioners 1, 2, and 3. Who are apprehending arrest in connection with an FIR dated 26/5/2023, which was lodged by the informant. Post of in the said FIR, it is alleged that the accused person number one had married the deceased son of the informant about 23, 24 years ago. Post they had 2 sons and the elder one expired about a month ago from the date of lodging the FIR. Posting. It is alleged that the accused persons, accused number one, had physically, mentally tortured her son and had conspired to against her, they conspired against her son and demanded money from time to time. So, on 25/5/23, he was it was stated that he was coming out from the house of his in-laws in the bike belonging to accused number 2. So he fell down, injured his head. He was brought to Bongaigaon Civil Hospital for treatment. But he was referred to Borpeta Medical College for better treatment. So, however, on his way to the hospital, he died at about 10:45 p.m. It is alleged that the son of the informant died as the accused person's name that conspired physically and mentally and tortured, inflicted torture. MS SH Bora London APP submits a CD along with PM report. He called for. Let CD be called for along with PM report. In the meantime, if the accused persons are arrested, they shall be released upon furnishing a bail bond of 30,000 each with 1 security of like amount. With the satisfaction of the arresting authority, they should appear within 10 days. Matter be fixed again on 9th of August.
14.
306, my lord, abatement to suicide, my lord. The girl and the boy, it is, the allegation is that they assumed that because of this, the girl was in love with this boy and that love did not culminate. And they assumed that probably there are some photos in his mobile phone because of which the girl committed suicide. That's the allegation in short, my lord. The realm of assumption and suspicion. Page 8.
What is the name of the accused person?
The accused person is Tawfiqul Rahman.
There is no assumption, there is a specific statement.
Therefore, we can assume
No.
that though she
No.
committed.
Kindly come to page 8,
Yes, I'm reading it.
before therefore. Accused so and so. Have you found out? There is a specific statement that you have recorded.
No, no, these are, because there is no direct declaration. These are all made in the realm of assumptions, my lord.
We'll see about that.
It is recorded some nonsense photographs. That is the
They assume that these are recorded.
No. Assumption is that she committed because of this, suicide because of that. But there is no assumption in respect of the video recording.
not.
That's a specific statement. Threatened her,
How can somebody,
we don't know.
how can somebody know what happened in the lifetime of a person who is no more?
That person is a daughter, I think. Daughter, who's the informant? Who's the informant?
Happens to be
Father of the
father of the,
victim.
Father of the victim. What is so strange about the father knowing what is happening in her daughter's life?
after she is not there.
Maybe she knew it before that. He might have known it. Why are you presuming that they don't know?
No, my lord, I'm just, my lord, subject to what your lordship says, my lord. Why I'm saying, if she had all this in her.
These are matters of investigation, prima facie.
No, my lord, I'm not
there is
against
a-
investigation, my lord, I'm not.
There is a statement that you have recorded something. There is a statement that you had a long-standing affair.
I'm not, my lord. There are many judgments which say that not only because of a romantic relation, if one of the partner commits suicide, the other cannot be held for abatement. There has to be some overt act.
Correct. So all these are matters of trial.
Absolutely, madam. That is what I'm saying. These are matters of, my only submission is whether cellular interrogation is required at this time. If required, they can take my mobile phone, I'll give everything, madam.
Yes, what do you say?
At this stage, CD.
That when it comes to the parties, let this petitioner, so and so. What does he do? Petitioner,
My lord,
what does he do?
none of the petitioner as such is barely 22-year-old man. He's in search of a job, my lord.
Oh. So and so is apprehensive of being arrested in connection with an FIR dated. What is the date of the FIR?
My lord, the date of the FIR,
23/3/2023. Lodged by the informant one Iftikhar Hussain, who's serving the state FIR. It is alleged that his daughter was about 17 years old, committed suicide by hanging herself inside the room after returning from Borhola Chariali when no one was at home. Also, it is alleged that later on they came to know that there's a long-standing love affair with the petitioner. between the petitioner and the deceased. Full stop. It is further alleged that the accused person had recorded photos and videos of objectionable intimate moments with her daughter and threatened her that if she does not act according to his wishes, he will upload the photographs in the social media. So it was therefore suspected that she committed suicide by, in view of the threat issued by the informant. Learned APP submits that. Before that, learned counsel for the petitioner submits that there is no specific allegation that petitioner is responsible for the suicide, for the death of the informant's daughter. So to be submitted that merely because there was a relationship between her would not should not be the prime, should not be the sole ground of suspecting that the petitioner is responsible for the death of the informant's daughter. Learned APP submits that CD along with PM report before. Let us have the CD and PM report first.
Can I go and give my mobile phone and everything so that they can verify all these things? Or else I'll be unnecessary, my lord, I'll be prejudice because of that. I'll go and give my mobile phone and everything.
It's a short
Let
paper.
them-
That is a case study.
That will better
You're
help
right.
the investigation, my lord. I'll go and surrender my mobile phone and everything, let them verify. If anything objectionable comes up, my lord, your lordship is at liberty to cancel my bail. With a positive direction that I will surrender all my mobile phones. Let them verify.
In the meantime, if the petitioner is arrested, he shall be released on furnishing a bail bond of ₹30,000 with 1 local security of like amount. Shall appear before the IO within 10 days from today. He shall cooperate with the IO and furnish all details with regard to his relationship with the alleged relationship with the victim, if any, including photographs as well as digital photographs. All recordings, etc. But he should not attempt to influence any person or witness. He shall not attempt to out of the jurisdiction of Warhol PS without written permission of the IO. They shall report to during the course of the investigation, they shall report to the IO. Every 15 days. Please begin on 9th August.
Statement within 10 days. And
10 days.
my lord, I beg my lord's indulgence. Item number 45, there is no case interview. My lord, interview is there. My lord may give any date. My lord, go ahead.
We'll pass orders as and when it comes.
Document speaks on 9th.
9th August.
15.
My lord, the FIR, my lord, page 11, my lord. Here are, my lord, the 7 petitioners before your lordship. This is long FIR, my lord, it is stated that, my lord, first regarding posting of magic pack and the photo, technical, my lord, there was a quarrel and followed by, my lord, mutual market with the brother-in-law of the, my lord, informant, my lord. And in the next day, my lord, also The accused person, my lord, the allegedly, my lord, attack on the, my lord, father of the informant, my lord. And false state, my lord, nothing happened like that, my lord, they attacked, my lord, my lord,
Yes,
Should case study on statistic.
only my lord, stretching, my lord, we have indicated serious, not some, my lord, they are not stretching, cold state, my lord, and etc. Is also identified.
heard learned counsels of the parties for proceeding along with injury report. How many petitioners?
Seven.
Seven petitions.
Well, let us consider their case after perusal of the CD.
Not sure.
My lord, they protected, my lord, they will appear.
And there is also education, serious head injuries.
Hmm.
Because my lord, this is my lord, false allegation of my lord case. Regarding my lord, proceeding of my lord, two vehicles, my lord, they are quarreling with the party.
What are the names of the petitioners?
My lord, petitioners, my lord,
Except version 7, all the petitioners with the lodge.
Except 7?
Except accused of the 7 version. All the petitioners are there.
Let us call for CD. Then injury report. Heard learned counsels for the parties call for CD and injury report list on 20
On 20th of June.
20 June.
Lodge.
We'll consider the prayer after going through the CD.
16,
Consider your prayer after going through the CD.
my lord,
Fixed on 20 June.
22, my lord.
20.
Of my lord,
16,
Yes, Mr. Shoni.
Where is your option? No, anticipated the application, but the acquired page relevant. Case is registered under section 363 and 376. The marriage lady, my lord, doing some, my lord, relation develop. It is in the present petition. Then she had made a declaration which are annexed at my lord page 19. That she was married also my lord by a Kabir executing a Kabir on 26th of September 2021. And presently, my lord, their marriage has been, my lord, resolved also. This is the case.
Resolved.
Now there is resolvement, which he had given a declaration.
Hmm. So who are the petitioners? 2 and 3? 2 and 3?
You will see another city police, my lord, their relation.
I heard Mr. A. Chaudhary, learned counsel for petitioner, and Mr. Sech for all and other people of the state. If the petitioners apprehend arrest in connection with an FIR dated 4/11, 22/11, 22/10, 2021 lodged by the informant. Also, learned counsel for the petitioner submits that the allegations made in the FIR false. And concocted in view of the fact that the informant subsequently had filed a declaration by way of an affidavit dated 2nd of May 2023. Stating that the marriage between petitioner number 1 and her, marriage between her and petitioner number 1 has been dissolved. And they will no longer be considered to be husband and wife. Also, it is further declared that pursuant to the dissolution of the marriage, they shall not. They are free to remarry, and there shall be no objection from either side in the event of remarriage. Also, learned counsel for the petitioner therefore submits that in view of the declaration made, the allegations in the FIR are clearly false and are directed for harassing the petitioner by the informant, petitioners by the informant. And as I said, Boral and APP submits that case diary at this stage we call for. Case diary along with medical.
Lordship, it has happened in the year 2021, but
Medical we call for. Accordingly, let CDB call for along with medical report. In the meantime, if petitioners are arrested, they shall be released on furnishing a bail bond of rupees 30,000 each with one solvent security of like amount to the satisfaction of the arresting authority. They shall appear within 10 days from today. They shall not hamper or tamper with any evidence. They shall not attempt to influence any person or witness, and they shall not move out of the jurisdiction of Nogao police station without leave of the I. Least in the month of less than 9th of August.
17.
Elevation under section 306. Brother of the informant committed suicide murder, and it has been suspected that I have committed the suicide murder. There is no specific allegation how and when I have instigated or edited. No specific allegation. I am nowhere related to the decision. We were known to each other, being workers of a political party. Being my senior member, he used to call me and he used to share day-to-day activities of the party. Later on, he developed some feeling for me, he has proposed me for marriage, and being a married woman, and he was also married, but it was not acceptable for him. And he used to also say that he was not happy with his married man.
Learned counsels will practice. Petitioner is approached this court by these anticipatory bail petition apprehending arrest in connection with FIR dated 23rd of April 2023. Filed by the informant one Aharbaman Pancho. Also, it is alleged in the FIR that his brother, the brother of the informant, one Harlong B. Pancho, was found dead by hanging inside the soil conservation IB at Kohora on 21/04/2023 at 4:30 p.m. It is alleged So it is alleged that the petitioner is the prime suspect who abetted the brother of the informant to commit suicide. Learned counsel to the petitioner submits that these allegations are false and no such thing happened. Also, the petitioner and the petitioner and the deceased person were workers of a political party in the district of Karbi Anglong. In the process, they came to be in the process of the party activities. They came to know each other fairly closely. Also, subsequently, the petitioner, the deceased person, expressed that he was not happy with his married life and approached the petitioner to get married with him. Full stop. Such proposal was denied by the petitioner as she herself was married. Accordingly, he submitted that the allegations are false and lodged as mere on the basis of mere suspicion. Also, Para learned APP submits that CD along with postmortem report to go for at this stage. Para accordingly let CD and along with postmortem report be called for in connection with so and so case number. Dolamara PS case number so and so under section so and so. Also, in the meantime, if the petitioner is arrested in connection with the same case, he shall be released on furnishing bail bond of rupees 30,000 with one local security or like amount to the satisfaction of the arresting authority. Interim bail is recording interim bail will be released on interim bail. Petitioner shall appear before the IU within 10 days from today. She shall not hamper or tamper with the evidence. She shall not influence any person and she shall not move out of the jurisdiction of Dolamara PS without leave of the written permission of the IU.
11 to 10.
Released again on 11th August.
18.
Made is a petition under section 430 that is page number 14.
Yes. Yes.
With reference to the subject stated above, I have the honor to inform you that on 21/5/2023 at about 1 p.m. based on secret information, I along with office staff page Nagasaki on NH37 in front of Navy of B during Nagasaki one vehicle behind the station of Procedural coming towards Meghalaya from Lakhimpur South was stopped and checked thoroughly in which found carrying 31 number of goods and one dead loaded in the state truck which was congested any negligence conduct was taken. Further, the driver of the state truck failed to produce any valid documents of the loaded goods as well as failed to produce livestock carrying permit of completed authority. Thus, it is strongly suspected that the goods may be stolen from somewhere. During interrogation, the driver so and so and helpers so and so were thoroughly interrogated and they stated that they carried the state goods from Pandurdual, Lakhimpur, Arunachal border to Bonihat, Meghalaya state steadily to mobile phone purchases. So it is a case of suspected stolen cattle and these cattle have already been seized and the driver and the helper have already been arrested.
So who are you?
The petitioner before your lordship is a lady of about 37 years old and the owner of the truck.
Owner of the truck.
Is the owner of the truck. The truck has already been seized. So if you want to take the name of the truck and
Yes, madam.
Lordship, otherwise there's no special actors there, Lordship. Whether your Lordship is going to take this notice.
Hmm?
The special acts are there.
Registered under?
Lordship, Assam Cattle Preservation Act and there's a prevention of cruelty of animals in 1960.
Is it before any other bench? Oh, sorry. Is it before any other benches? Huh? Then it will go before that bench.
No.
Why was it
Better
rescheduled?
come up tomorrow, you'll get that.
Tomorrow.
Why is it?
Tomorrow, bring it to the notice of bench.
It's a 50 days tomorrow. you'll get.
19.
This is the second bill. And it's the last order page 15. Page 15 last two pages, correct.
Heard, unit counsel for the petitioners about proceeding. Anything else?
No.
Only CD,
Applicant city is what the postmortem is.
up to the CD along with postmortem report. It's coming from
It's from Pocket Construction to be
TN. So, when can you get it?
22nd of August. June.
22nd of August.
20.
Taken after some time. My senior is taking after.
What is this after some time? Where is your FIR?
He'll be coming after.
Where is the FIR?
I don't have the bill. The bill is with me. Right.
21.
No question. Question of the person videos. Let's be okay. Please manage it except the question.
Hmm?
You have to file a fellowship. There's 70 extra cooling. I want to file a fellowship.
Huh?
I want to file a fellowship. There's about 70.
Who is filing page 9? Page 9 is who the FIR?
Mother of the victim.
Mother of the victim.
Yes, sir. And case 17 filed by me.
Is it process that?
On the same fellowship, my later earlier
17.
71 fellowship.
17. Translated version.
And with the traditional version. This is earlier letter. Therefore, they are a lot like that.
Learned counsels for the parties. CD along with injury report be called for in connection with
Not copy here.
not Guwahati PS case number
57.
57
57 of the 2017.
and 56,
Yes, we can 56.
56 and 57, 2023. List it. When can you get it?
Lordship, on 16th, Lordship.
Why 16, not Guwahati,
On
just across the river.
14, on 12th, Lordship.
Huh? 12,
Lordship.
along with injury report,
Lordship.
just on 12.
22.
Can be found on the tab.
Twenty-three,
That's it, Lordship, this court appeal bail application, that is in page 9. The allegation is that my lord, allegation is that my lord, I demanded money from the informant and I assaulted and I attacked the informant. And I demanded money to buy alcohol. That is the allegation. The allegation is totally false. My lord, actual fact is that my lord, kindly see my lord in paragraph 4 in my petition, my lord. The page 4, paragraph 5. This is the actual fact. Then my lord, on the alleged that my lord, the petitioner was on his way back home from his work, and he made the informant who was unable to work properly, and as he was inhabilitated and was stumbling around and bumped into the petitioner. At that moment, some altercation took place between them, and both pushed each other, and both of them fell down, my lord. And due to which, my lord, both got injured, my lord. Actual fact is that, my lord, the allegation brought against me totally false. Lord, in this similar case, they may be called for, and in the meantime, I may be protected. This is what happened.
Yes, you call for CD along with injury report first.
Lordship.
It is coming from Kamrup Metro,
Yes, upon place.
hard letter councils to the parties. Call for CD in connection with CD along with injury report in connection with cut down PS case number so and so. List on 12.
13.
12.
for admission, item 24.
None appears next week.
25,
Here, according to the application, we are paying for custody of the vehicle. Just seized on 9th of August 2022. Police report was called for also.
Is it available? Report.
Police report is
Perhaps that is in the office. Let me verify just after something.
bail hearing PA, item 26.
Look at court attendant bill application. Petitioner is behind the bars for 45 days today. Allegation under 376 and 506, 511 of I6. Okay. This is the third time notice PD has been called for.
Yes, sir, but she did not receive matter.
Why?
Sent message matter that the earlier matter 24/5, the law and order duty, it could not. Can be diary. And read for 600 days.
In spite of orders passed earlier, CD call for has not been received. As submitted by Learned DPP, Mr. So and so, close to. Accordingly, let, as a matter of purely in the interest of justice, matter is deferred for 2 weeks or 1 week, enabling the Learned DPP to produce the CD positively by the next day, along with medical report. Mr. So and so appears for the petitioner. This again on 13 June. 13 June.
Project.
27.
CD,
Yes, still died in its.
Keeping custody.
the 90-day offense.
Yes, my lord, yes.
What is the stage of the investigation?
Investigation, my lord, almost complete. Some other accused is there, my lord. That is otherwise. Open case is the statement of accused. Then 164, I have read, my lord.
Yes. FSL is waited.
my lord.
Something sent for FSL.
No, that is the portion others, my lord, that others, otherwise, my lord, she implicated. And he also himself admitted, other co-accused statement is also there, my lord.
Then why don't you file the charge sheet?
And some other co-accused is there, my lord.
All right. How many days?
5
Hmm?
55.
90 days of it.
When were you arrested? When were you arrested?
Yes, 11th of April.
Not 11th. You're forwarded on 7th.
14.
Right.
11th.
You haven't,
11th was re-forwarded. 7th was arrested.
Huh?
7th was arrested and 11th was after custody. He was re-forwarded.
where have you stated that?
No, it is page 13 reflects that. Page 13, the first paragraph, with reference to the subject cited above, I have the honor to report that and forwarding here with bail on the registration after completion of the remand period with effect from 7/4/2023 to 11/4/2020. So in that count, almost 60 days.
Heard learned counsels to the parties. This DA petition is filed by the petitioners. Petitioner 1. Who was arrested on. When was he arrested? 7th.
Yes.
7/4/2023. In connection with an FIR dated 4/4/2023 lodged by the informants. It is alleged by in the FIR dated so and so that the petitioner by the informant that she was forcefully taken in a four-wheeler vehicle on her way to Dhemaji. Post of she was made to drink water, which was mixed with intoxicated substance. Thereafter, she was brought to an unfamiliar place. Full stop. When she got her consciousness back, she found that the accused persons along with 5 others committed rape and left her naked. Thereafter, she entered into a house where the people of that residence gave her some clothes and took care over her for about 2 days. He had identified the accused And he was arrested by the police. And his name was Abdul Hamid. This court had, the police thereafter proceeded with the investigation. This court thereafter called the CD. The result of the CD reveals that
Here are some films.
reveals that the petitioner had recorded a 164 statement where she implicated the accused persons specifically. Most of the statements of the accused persons have also been noted. From the CD, it is seen that the matter is still under investigation and some other accused persons are yet to be arrested. Charge sheet in the matter has not been filed. Upon due consideration of the material available on the CD, upon hearing the learned counsels for the parties, it is seen that the allegations and the made in the affair are grave and serious. The petitioners, if convicted under those sections, the punishments prescribed are severe. Considering the fact that the matter is still under investigation and in view of the evidence, which incriminate the petitioner at this stage of investigation, this court does not find it a fit case for the bail petition to be granted. Bail prayer to be granted at this stage. Bail petition is then accordingly dismissed. CD return. We are rejecting your bail petition.
Okay.
28.
28 died in democracy.
Nana DPP submitted the CD called for has not been received.
The bar of 32 days.
Let the CD be called for. Let us wait for the CD. When can you get it?
20 minutes.
Chapor.
The petitioner was absolutely innocent, my lord. And the allegation brought under section 376 and others, my lord. But the victims committed suicide due to the torture of the husband.
So we'll see from the CD. Let us wait for the CD. List on 20. 20.
29.
Chapor. Ek minute.
Case number 1743.
114.
Yes, my lord.
CD available.
No, my lord, she did not.
Please call for CD on.
Yes, 29 minutes. 29 died. 29 died.
No. The earlier matter. We are fixing it on 20.
My lord.
Yes.
May I please, Lord, 439 application of it. Accused you of arrest on 7/5/23. Today is the 30 days in custody. Trial of till final day 15.
Yes.
He is catching a mobile. From the informant he was giving the back number of the petitioner. Thereafter he was called to the police station. Thereafter he was there. Regarding,
He is the owner of the bike.
he was the owner of the bike. Like no description of mobile and number, nothing is there. And nothing was recovered from his possession. Even he was taken 5 days in police custody, nothing was recovered. Moreover, he is also an advocate by profession. So at that given point of time, he was at Kangaza, along with his pair.
Somebody will have to give him some briefs, otherwise what will he do?
As because his number was given.
Uh,
Number was given, so number he was called.
He has given it to somebody. The bike, he had given it to somebody.
That is not there. Bike was with him.
Then
Some vendetta must be there with his father. Also. That I have taken you. Correctly.
mobile phone was recovered.
Not recovered.
So whose mobile phone is
This
this?
mobile phone not recovered, the vehicle number which was given by the informant.
From there, they have from this Vahan.
No, that's all right. There is a picture of a mobile phone also. Whose mobile phone is this?
So this mobile belongs to him. To the accused petitioner. His motorcycle and mobile was seized by the police.
That stolen mobile not recovered.
Stolen, not recovered. This mobile belongs to the petitioner. Along with the bike, it was seized.
Where did the incident happen?
Near flyover. Tanmay flyover. And nobody from that place was also examining this flyover.
Our Mr. Talukar and counsel for the petitioner, Mr. P.V. Goyal and the PP for the state. This be a petition. Filed by the petitioner. Seeking bail as he was arrested in connection with. The FIR dated 6/5/2020, filed by the informant. Also, it was alleged in the FIR that when the informant was walking towards Janmari flyover, two unknown persons came from behind her back on a motorcycle. And the person sitting behind in the motorcycle snatched the mobile phone from her hand. The registration of the bike was AS01DJ1543. Also. And it was requested that legal action be initiated against the motorcycle and the riders. Also subsequently, when the police located the mobile phone, mobile number of the owner of the motorcycle, he was called to the police station. Most of the informant identified the motorcycle as well as the person riding the motorcycle. Also, accordingly, case was received and registered as January VS case number 164 of 2023 under section so and so. By order dated 3005/23 and called for the case diary. Most of the case diary has been presented before this court. When a case diary has been carefully perused, it is seen from the case diary that the motorcycle bearing registration number so and so belong to the accused persons. However, no mobile phone was recovered from no mobile phone belonging to the informant was recovered from the accused person, accused petitioner of the department. From the statement of the informant as well as other informant, as well as the investigation carried out by the police, the mobile phone has not been recovered from the petitioner. Also, there are no materials seen in the case diary which suggests that further custodial detention of the person is necessary, although no charge sheet has been filed in the matter as yet. No materials are noticed from the CD which suggests that release of the petitioner on bail at this stage of investigation will hamper the investigation carried on by the police. Post of considering the upon the result of the CD and also taking into account taking into consideration the period of detention undergone, this BA petition is allowed. Petitioner is released on bail, subject to furnishing a bail bond of ₹25,000, including 1,000 local security, to the satisfaction of the CGM Kamrup Metro. Petitioner will not move out of the jurisdiction of Chanmari PS without written orders from the competent court. AB petition accordingly stands, BA petition stands allowed, and CD return.
Not. Supplementary list. Bail hearing at 52. Madam, as per occasion dated 3/6/2023, status report not received after this.
The orders like the. Orders like by the.
Orange pen.
Yes, long one.
Yes, yes. Status report not received. How much time is it required?
And it will come to release the money. After 1 week.
1 week.
1 or 2 weeks.
Status as per office note 3/6/23, status report call for not received. List after 10 days. 22nd. 22nd.
Then it is when hearing item 30.
This is the episode was from. Things long. They are sending for episode.
Long it is pending.
What about his statements? Statements recorded?
Yes.
What is the FIR?
Is it translated portion at page 8? Yeah,
They wait for FSL. List again in the month of August, calling for the FSL report. CDB return back, calling for updated CD. Fixed on 9th of August for updated CD along with FSL. Interim bail granted will continue. Interim order will continue.
31.
Here also diary is not up to date. Not to date diary is
Submitted by the learner APP, their updated CD is required to be called for. Accordingly, let the matter be listed again, calling for updated CD. List on 9th August, interim order passed early will continue. Mr. Richard Chaudhary, Learner Senior Counsel, assisted so and so, appears for the petition.
32.
32 diary not received. Interim is
It is submitted by learned APP that CD call for has not been received based on 9th of August. Interim order passed early will continue. Yes,
33.
53.
charge sheeted.
Yeah.
It is submitted by learned APP that charge sheet in the matter has been filed in the meantime by the charge sheet number.
Statute number 2, I think. It has a set.
You get it? We will take it up.
PIB solution. PIB, I think it's 30. Yes.
Do you have the number?
That is not there, my lord, that it is saturated meter, my lord. CIB file, another meter also there. Number I will check, my lord. After some time I will.
We'll take it up after some.
Yes.
It is submitted that charge sheet in the matter. We'll dispose it of, you supply the number.
My lord.
It is submitted by the learned APP. The charge sheet in the matter has been filed in the matter. Therefore, the petitioner be directed to appear before the competent court. Accordingly, this petition is closed. Also, let the petitioner appear before the competent court for bail, if so advised. Also, however, the benefit of interim bail granted on 15/12/2022 will continue for further period of 10 days from today, enabling the petitioner to appear before the competent court. But if none appears, how will the order be communicated?
None appear.
How to communicate? The registry will communicate the order to the petitioner as none had represented the petitioner on the matter being called. You supply the number.
My lord, my.
34.
For my lord, here up to this diary was about for diary up to 21/9/22 only. September 21.
As per Honorable High Court's direction, Lordship, the petitioner approached before the land court below, Lordship, and land court proceeded directly to release the his property. And within the order, Lordship, may I submit it, sir.
What?
As
You're
per
on
Honorable
bail. You're on bail.
Yes, Lordship,
Ah,
but the custodial property, Lordship,
ah,
already released by the Honorable Court, Lordship,
ah.
directed to release the property.
That is another aspect. Now you are on bail.
Yes, Lordship, but I am the owner, Lordship, and the property was seized by the authority, Lordship, from one vehicle, Lordship, and I am claiming that I am owner. This Lordship, a fatal matter, subjected to the farming supervisor.
Hmm.
Now, Lordship, in 6 days, Lordship, Both party council take time, Lordship.
So there location is.
Mr. ABB, Mr. BB Goel and
And no other claimant.
ABP submits that the up-to-date CD is required to be called for increase for further times. Mr. BU lost for learned council appears for the petition submits that he's on interim bail and the bail be extended in the meantime. Accordingly, let the matter be listed again on 11th August. Interim bail granted earlier will continue. Your release of Supari, you can bring it on record if you want, bring it on record. Bring it on record if you want. We are fixing it on 11th August.
They have failed, Lordship. They have failed to produce anything against me.
You're on bail, interim bail, so it will continue till 11th August.
35.
In this case, Lordship, we recognize the interim Lordship and please appear, Lordship.
Diary notice.
Learned APP submits that CD paper has not been received. List again on 11th August, enabling learned APP to call for CD. Mr. AMS Muzumdar, learned council appears for the petitioner. Interim bail granted earlier will continue.
For that.
36.
The petitioner the 18th of the appear before the annual notice, and I got a statement notice.
Yes.
Injury for call for notice. The allegation against the petitioner is notice, the petitioner pointing out what are on the body of the informal notice. That is notice, the part is eligible notice, government was the. Very good.
Yes.
Unlawful book based on user agent, Zoar, not act as of Sometimes for the Bagler community view, fear of what can at the other Dosto has been. It is how my prior Akman Badishit. A series meeting under the Kotokoto meeting, another British for the Piscina for a mood, Soto, Aru, they are Sotulo, Gorompani, Dali, Mook, Panamora, the services, with the alien.
Injury report not received, my lord.
Learned APP submits that injury report call for is not received. Therefore, praise for further time. List on 11th August, enabling him to call for the injury report along with the CD. CD received.
The CD received, my lord, without injury report.
Let updated CD along with the injury report be produced on 11th August. Interim bail granted earlier will continue till the next date.
37.
11th August.
37.
Yes, Mr. Lordship, court has cleared the application, Lordship. CD was filed.
It is the then starting submitted.
Rashid submitted.
Lordship, I am a government as government employee, Lordship. I may be protected until I appear.
Learned APP submits that charge sheet in the matter has been submitted accordingly. As the review petition stands closed. MS
Petition.
P. Sharma appears for the petitioner, who submits that the interim bail granted be extended till the petitioner appears before the competent court and applies for regular bail.
CS number 1/23,
A,
dated 29/1/23.
accordingly, review the charge sheet having been submitted by the charge sheet number 1/23 dated
29/1/23.
29/1/2023. The petition stands closed. The petitioner is at liberty to appear before the competent court, appearing for regular bail, praying for regular bail. And the benefit of interim order dated 10/2/2023, granted by earlier by this court, will continue for another 15 days from today. The petition stands disposed.
38.
Charge sheet.
Yes, ma'am, that same case, ma'am, CID 5, the earlier one matter, and this is another matter also, item 40.
Item 33 and 40.
I will on 7/12/23.
Hmm?
The phase minor 20 minutes.
The substitution I got, no? In instruction I said.
You take up
After some time, my 38, 40 also. 40 also.
38 or 33? 33.
No, item 38 and item 40 also arising out of same affair.
This is item, what is this? item?
This is 38 measure.
38, okay.
Yes.
Okay.
39.
39 diary receipt.
Yes, read. You read the vernacular, page 8.
সম্মানপূর্বক বিহিত নিবেদন এই যে দুয়ারা ইংরেজি 16/6/2022 তারিখে দুপুরিয়া এক বজার মোর ভতিজা জামাল উদ্দিন পিতা সালামউদ্দিন খান কলকাতা একমখণ্ড নিজের ঘরের পদুলি মুখত বহি থকা অৱস্থাত উপৰোক্ত উল্লেখ থকা আসামীজনে পূৰ্ব আঠেজক পিছফালৰ পৰা দৌৰি আহি থকা অন্তৰেৰে বুকুত ভাঙি গুৰুতৰভাৱে জখম কৰে। তেওঁ চিঞৰ বাখৰ কৰাত ওচৰৰ মানুহ আহি তেওঁৰ প্ৰাণ ৰক্ষা কৰাৰ আসামীজনে প্ৰাণে মৰাৰ ভাও দেখি তাৰ পৰা দৌৰি পলাই যায়। তৎক্ষণাৎ জখমীজনক বহুৰি চিকিৎসা মহাবিদ্যালয়লৈ লৈ যোৱা হয়, কিন্তু জখমীজন সংকট অৱস্থা দেখি ধুবুৰীৰ পৰা গুৱাহাটী চিকিৎসালয় প্ৰেৰণ কৰা হয়। বৰ্তমান জখমীজনক গুৱাহাটীৰ চিকিৎসা উন্নত চিকিৎসা হৈ আছে। জখমীৰ চিকিৎসা ব্যস্ত থাকাৰ কাৰণে এজাহাৰ দিয়া খৰচ। There is a deed of 14 days.
Hmm.
There are some instructions. Medical was not. Regarding some options, I have already got an alternative ready. Please wait.
Is a person dead or what?
No. It's alive.
There is a dying declaration.
That is there. Reported as a dying declaration, but
They thought he'll die.
not dying. Have you seen the movie?
What is your name? What is your name?
Someone listening.
There are some, he had to undergo some operation, something is there. Then
There was a 14 days, after 14 days, because
maybe Mr. Gogoi.
No, see. Here, my lord, injury report not clear.
Not clear. You have to get it from the, I think the primary health center where he was initially sent. There is an endorsement that it has to be, details to be taken from that hospital where
Yes.
he was attended to.
But
See if
I
you
have
can,
not collect.
you see if you can get it. Let us find out. We'll give a short date.
Yes.
The detailed injury report as called for is not available in the case diary. Then at APP has paid for a short date, call for the same. Let the matter be listed again on 20/20/06. Enabling Leonard APP to call for the case diary. Mr. So-and-so and counsel for the petitioner appears for the petition.
that all billing that will be discussed.
In the event, the case, in the event, the detailed injury report is not furnished by the next date fixed, court will consider passing appropriate orders. CD return.
Item 41.
Diary is.
Application number 1 and 3 are in the interim bill, and they have explained because the I also page 11 is the advance.
This is the statement.
Interim bail granted,
2, 1 and 3, man.
1 and 3,
Man,
only one.
2, 1 and 3 possibly. Lordship order is there regarding number 3, man.
Only one.
So 1 was granted,
3 was granted earlier. Yes,
yes, man.
yes. 3 was granted earlier.
Man. Then what is that, my lord? Is number, petitioner number 2 had some relation with the lady who committed suicide. But she was below the age of 18 years, well, that's why, my lord. And at that point of time, my lord, the child marriage arrests were on, my lord. So it was decided by both the parties that she will be given back to her father. And once she attains majority, my lord, she will be married will be performed. On 4th, my lord, this number 1 and number 3 went to Majuli, my lord, and handed over the lady in question to her father, my lord. Subsequently, after 10 days, my lord, on 14th, she committed suicide. Now, offenses under section 306, my lord. My humble submission is, my lord, regarding 107 ingredients that are missing, my lord. So far as my instigation part is concerned, and otherwise diary is there, my lord. And approximate length is also not there.
How approximate link is not there?
My 10 days of my, because on 4th, my lord. On 4th, she was handed over back to her father, my lord.
This is under 306.
My lord.
Oh, 10 days is there any specification that 306 for 306, the proximate relation has to be within a particular time frame?
Because at the time of handing over of the lady, my lord, she was, my lord, mature enough to understand that because of that, my lord, minority or whatever it may be, my lord, 17 years, the marriage could not be solemnized, my lord. That's why I'm saying, my lord, otherwise, my lord, the allegation of 1 by the petitioner number 1, that she was made to wash the hand of a dog, my lord. And in that process, the dog bite her. Apart from that, my lord, no torture, nothing.
Even my lord, official report was for idea and like that official report not received.
Here we look at.
Yeah. When can you get it?
That is, here in interim, I have no problem.
So 1 and 3.
Suppose
2 is not on interim.
2 is not an
who is not in.
List on 27th August, 27 June.
Who is not in interim, my lord, but his statement is here, my lord,
already
in the diary.
Okay.
I do not know.
Then it is not necessary.
Yes.
We'll keep it on June 27th,
Yes.
calling for FSL report
Right.
along with CD and duty report. At the request of Mr. B.V. Gogoi, Mr. N.J. Das, Learned Counsel appears for the petitioner. Interim bail granted to petitioner 1 and 3 will continue. Based on 27 June.
Man. Okay. 42.
42 no diary.
So it is submitted by Learned APP that CD called for has not been received. He prays for a short day. List taken on 11th August. Mr. N. Upadhyay and Council submits that petitioner is on interim bail. One petitioner. Interim bail granted earlier will continue. Interim will continue. List on 11th August.
11th August.
43.
Nothing. So school can read application. Other than the interim and I putting the appeal before.
CD, where is the FIR?
The price that the. Page 7 was. Unable at 10. 9 was 9.
Very good.
Yes. What happened to the accused number one?
Accused,
Accused British person number one. Is he arrested?
no, Lordship, 4:30.
Accused one.
He released on date.
Accused one.
No,
Released on bail after arrest.
no, Lordship, anticipatory bail perhaps.
No, we are not composed around, no,
Police say, not having.
no idea.
CD.
City received Lordship, and the statement is recorded after getting interim notice.
No, sir.
And I have found also a separate report from the IOS, as well as a statement of the witnesses. And he's an employee of the Tata Motors Finance Lordship. And already Lordship registered owner that has ownership is asserting, and the Jimma vehicle has been recovered and seized accordingly. And Jimma has been given to the registered owner. And he's an employee of the Tata Motors.
Finance.
Yes.
Vehicle was taken on finance.
Vehicle was taken on,
Finance.
finance Lordship.
And there are two owners also. One Babu Ali is the first owner. And actually, originally the owner is one Lordship, Agarwal. And he has taken the loan on, taken the vehicle on finance. And thereafter he sold it off to the second owner, Lordship.
During Lordship hypothecation, one cannot sell this vehicle. Lordship.
Because of payments on the part of the original owner of the vehicle.
And everything in the name of Umesh Agarwal, not Babulali. And Babulali is finally certified, stating that he is the owner of the vehicle.
No, he's not an employee. He's the proprietor of some association and some.
Yes, Lordship.
Lordship, as per his statement, Lordship is stated.
Let us see.
I am the owner, proprietor of Ma Kamekhya Motors. Lordship.
And also-
According to, I have been authorized by the Tata Finance, Tata Motors Finance,
Yes.
to recover the vehicle which are in default of payment cost. I have authority letter, and in this regard, that is the for a vehicle, this particular vehicle, I have the authority letter to take repossession of this vehicle. Accordingly, I do.
This statement reflected the more Tata Motors financial arm for the employee. With the same time.
But your statement in para 3 is you are the owner of Kamekhya Motor.
Yes, Lord. This is true.
And then how can you be employed in Tata Motor?
Yeah, you can, but he thinks that he may be the employee of us. But this is clear.
He thinks or he may be.
The statement is something else. Lord. Statement.
You are on bail, you had gone voluntarily in terms of the, not voluntarily, in terms of the directions.
He may have some misunderstanding also. As because he has been authorized by the Tata Finance, so he thinks that he is the employee.
Yes, can I have the CD?
Lordship.
And whatever I have done, I'm authority. I authority.
Whatever you may do with authority need not be given a clean sheet always. It can be anything, merely because you have authority, I have authority to go and kill him.
No,
Does it absolve you?
to do this legal thing,
Ah.
to take the repossession.
Repossession will be as per the terms of agreement.
As per the terms, I have take possession. Accordingly, it has been informed to the local police, and vehicle has been deposited in the depot. And
Have you served him notice?
yes, Lordship,
You have to serve him notice.
in the part of finance, Lordship, they used to send notice. And the Umesh Agarwal, who is the owner, the notice has been sent to him, that annexure 5. And ICO Porpa, petrol post, that who has been informed. Everything was done. That's what it.
Our learned counsels for the parties. This heavy petition has been filed by the petitioner. Seeking anticipatory bail apprehending arrest in connection with an FIR dated 19/3/2021. Lodged by the informant, one MD, Babaul Ali. Also. In the said FIR, it was alleged that the truck bearing registration number so and so was snatched away from his driver at Roha, New Shariali by the accused persons. So threats were issued. And the accused persons had made huge amounts of money, demanded huge amounts of money. It is further mentioned that because of his illness, there was some delay in filing the FIR. Also, the petitioner was one of the persons named as an accused. So, apprehending arrest, the in bail petition was filed. This court by order dated 12/4/2023 had granted interim bail. Learned DPP has produced the CD. The CD produced has been perused carefully. It is seen from the CD that the original owner of the vehicle was one Umesh Agarwala, who had taken the vehicle, who has purchased the vehicle on finance from Tata Motors. The petitioner claims to be a person entrusted with the responsibility of recovery of the loan amount, defaulted loan amount, or upon failure by the purchaser to pay the amount, the vehicle is to be recovered. Full stop. Since, as per the reports of the finance company, the vehicle number so and so was shown to be on loan. Recovery was sought to be made, however, because of failure of the purchaser to pay, the vehicle was the vehicle was recovered by the agents, including the petitioner. Also, there was no threat. From the materials available in the CD, it is seen that the matter is under investigation, and the petitioner, and there are no materials to suggest that petitioner did not comply with the directions granted by issued by this court while grant of interim bail. Most of no materials are also available in the CD to suggest that continuation of the bail granted will hamper the investigation carried on. The vehicle in the meantime has also been recovered. Also, accordingly, the court is of the view that the interim bail granted on 12/4/2023 can be made absolute. Also, the same is thereby made absolute on the same terms and conditions. AB petition is accordingly disposed of, CD return.
Is there any condition that because of the last quarter losses, doesn't condition that I cannot take the PS?
Without written permission. If you want to leave, then you get written permission from the IU.
Okay, but I'm staying in Guwahati, but
You take written permission. We are not supposed to give you advices.
okay, from my duty, I cannot leave Guwahati without permission.
You read the order and comprehend whatever directions are given. Is we are not adding any new direction. Same directions on which the interim bail was granted. Charge sheet was it? Charge sheet file.
Time being item 38 and 40.
Yes, my lord, the circuit file, we have my lord 33, 38 and 40.
I have said because service, my name is not.
There is no.
Doesn't matter, but charge sheet has been filed. All three are interim bail.
1 minute, I'll verify and put below whether my name is in the service.
Your name is not there.
Your name is not there. Why have you got it?
I mean.
There is no case against you, that means.
I mean, that's a.
If you will extend it, beyond that, what can we do? Yes,
Yes.
you're not on interim.
No.
You'll have to appear. 33 years. Item 38.
38, 40.
38
40.
is submitted. CD interim assignment side. 38.
38.
It is submitted that
33, 38, 40.
the charge sheet in the matter has been filed by the charge sheet number 2, capital A, dated 17/5/2023. Accordingly, the AB petition stands closed. Petitioner is at liberty to appear before the competent court. And file appropriate bail applications if so advised. The benefit of interim order granted by the order dated 15/3/2023 will continue for a further period of 10 days from today. 15 days from today. Then item 33, same order, interim order granted on 15/12/2022. Benefit will continue for another 15 days. And in 40 days, no interim order, so we close it. You are at liberty to appear before the competent court.
44.
Yes, daily receipt. Thank you. Notifications against me, I'm a cashier below. And the section as a 209. I have a cashier company extended in the bank of urban cooperative bank. They are a mismatch of rupees 5 lakhs, which I have returned, we are about to be fine. That is at page 15, with a type copy, where it has been said, that on 15, the logic will find this incident has happened on 52 and the law apparently laws on 23. I was put under suspension because of the mismatch. In this connection, we have to advise a few LPs to put though by underscoring so in the account system, but then certainly found to be protected in nature. Moreover, it is reported that your logic is this is very important. On 15 to 2023, Sharma left the branch without permission after handing over. Well, I have handing over the day and cash of the branch manager during the time of reservation of the cash. The branch manager found a shortage of 5 lakhs. After the branch manager could not contact Mr. Sharma and his mobile was switched off, but he could establish contact with wife Sharma, wife of Sharma, inform her about the incident and requested her to contact Sharma and to convince him to come to the office with the cash. The branch manager also informed that that in the event of non-reporting of Sharma within a reasonable time, the bank will be considered to file FIR against Sharma. However, after lots of effort, branch manager Sharma of the branch manager Sharma reported the office and hand over the cash to the branch manager. So we have returned the money, which has been mismatched. In addition to the fraudulent transaction already detected, possibly, but there is a possibility which has happened in a non-value branch also. And there was in this branch also thereafter an amount has been credited in my name by my father-in-law. That was also put on the board. That is a surplus money. Now, this is the allegations. Thereafter, I have been put under suspension. I am in the, I am in under suspension. The money which the bank, there is a mismatch, it has been returned, there is a excess money. It is in the bank, you know.
Yes, my lord, the Hyflux, my lord,
He has admitted.
he admitted.
Then what to do now?
So that has been given back. You
No, no, given back means you have admitted.
know. What I, because there is a mismatch of.
No, no, not mismatch. You have given a.
I don't know what they are,
He has given a categorical statement that instead of depositing, I kept it. And after being found out, I have given it back.
Well, whatever it may be, but now, thereafter your lordship will find there's an excess amount of 5 lakhs.
But that.
That's a different thing, but now, well, I was put under suspension, my lord, whether my custodial detention is necessary or not, your lordship.
We don't know. But whether you should be granted the privilege of anticipatory bail in a matter like this, where you where defalcated money from the bank.
No, my lord, but it has been immediately returned back.
Maybe, but it was defalcated.
Well, it has returned back.
Then what to do?
And I appeared with that, I make my.
There is a case against him, my lord.
Yes.
That means, my lord, it amount admitted,
Everything.
everything.
Now, only thing is this, my lord, whether I was put under something, I cannot do anything. with that. Now, well, why a person has been kept under judicial custody, so that the investigation can be used smoothly. With here is a case, the money has been granted, and whatever the decision will take by the bank, that will be on me, and if the trial you find that, yes.
Then, no, then, for that, my lord, then will take definitely, so my lord.
No, that's
Now,
absolutely.
he has been suspended, now, what, now, about criminal offense.
Yes, that is why, why a person has been put behind bar. So that, the investigation can be, but that when there is a question of recovery, whether there is a severe, whether I can, influence the witnesses or not, these are reasons, so that is why the case.
By being on anticipatory bail, in a matter like this, you can influence.
Well, it cannot be, it cannot be because of the fact that I was put under suspension. If, had I been not under suspension, definitely,
We don't know.
I will manipulate, I will manipulate that these are the.
Yes, we want custodial detention.
That is the thing, whether I want the custodial detention or not, that has to be looked at.
After interim, he appeared, my lord.
My lord,
I had Mr. P. Bora, learned senior counsel assisted by MS Sunso, A. Bhattacharya, and Mr. B. V. Gogol, learned APP for the state. This AV petition is filed by the petitioner, apprehending arrest in connection with so-and-so FI. This court by the earlier order dated 12/4/2023 granted interim bail to the petitioner. And CD was called for, CD called for has been received. The result of the CD reveals that the petitioner has admitted before the IO that he has defalcated with the amount which however was returned back. Defalcated with the amount from the bank, which however amount of rupees 5 lakhs, which however was returned back. Also, the allegation in the FIR is that the petitioner had defaulted in deposit of he had left the branch without permission of the bank officials and without handing over cash to the day-end cash, END, to the branch manager. Pursuant to verification, it was found that there was a shortage of 5 lakhs of rupees in cash. Full stop. The petitioner stated before the police that there was a default on his part in respect of the said amount, which however he has returned back. Also, considering that the matter is under investigation and in view of these statements before the IO, this court does not feel further any custodial detention is necessary in the matter. Accordingly, the AV petition is allowed. The interim bill granted also in so days is made absolute on the following terms. On the terms mentioned therein. Full stop, it is further directed the petitioner will appear before the IO on every 15 days till completion.
Can we see the page 19 below? 19
Till completion of the investigation.
Here in paragraph 4 minutes, in this connection, however, you are to cooperate with the investigation process, due process, and may or need to attend the workplace. But I have to attend the workplace, Miller, for interview or other meeting related to the suspension or matter investigated in this department. So that is one of the conditions, Miller, by the authority, Miller, that I have to appear. 15 days I will appear.
You appear 15 days, every 15 days before the IO till completion. In the event of any attempt by the petitioner to influence any witness or intimidate any person connected with the offense or to hamper or temper any evidence, I will be at liberty to pray for cancellation of the court of appeal. If the petition is opposed, CD return.
Yeah. Because 48 application, and we will look at that. That is that case there. In fact, it is a complaint case placed before the Islamic Citizen may say, and we are paid for a direction to register a case and submit it. Because police did not register a case initially, but case 12.
Yes.
If I read case 12.
Yes.
Yes. Case 12, this is in the form of a complaint case, the is that the video lady is before your lordship's Monica Das Naghan, thereafter it goes on and on, the situation is this, in Morigaon, the erosion affected, so the ground survey resolution was changed, and when houses are proposals come, it is all decided by that is in the house scheme, then it is done by the Gam Soha, and whatever Gam Sabha says that we have to carry it out, with all respect, and the allegations show, certain houses where it is not defalcation of money, probably, the allegation, if I read it in totality, it has been allotted to somebody else, and to that effect, from page 12, 13, these are the allegations, What you can kindly see, page 13, the Awas plus, the scheme is. At the top, put line, page 13, Awas plus, and thereafter, with all respect, because I'll show the resolutions, that occurs at page 24 to 27. We have got nothing to do with it, and the video does not verify, verification of houses are done by accredited engineers, with all respect, These resolutions are 24 because of erosion, they took the resolutions again, 25, page 25. Now some resolution, how the houses were related. today's meeting unanimously agreed to the list of PMJOIA Avaska, which is read out. It goes on and on, my lord. The meeting unanimously agreed that although there are the names of beneficiaries who were benefited under earlier PMJOI scheme with the aforesaid so-and-so number of beneficiaries, their houses are in the grip of erosion. So they are to be entered again. Third proposal, the meeting unanimously adopted a proposal to delete the names. It goes on and on, my lord. And thereafter, after the police investigating agency asked us to submit documents, we provided all the documents, and thereafter, my lord, with all respect, my lord, latest query, my lord, that is at some page 38, my lord. We are asked questions, my lord, we replied also. 38, my lord. I'm sorry, my lord. I'm taking a minute. And the answers are at, this is the query, my lord, page 38, and answer is giving at page 39, my lord. They wanted exactly that, my lord, page 39. Question number 4, who emptied the, this is police language, my lord, who emptied the beneficiary data detail report? Answer from the video, my lord. Well, with all respect, my lord, page 39.
Yes.
Gaon Panchayat coordinator, Gram Rozgar Sahayok collected record documents of so-and-so beneficiary after PDA generated, which is approved by Gaon Sabha. Who registration of PMJOI houses beneficiary ID details report? Answer, GPCM computer assistant registered PMAY beneficiary. Thereafter, my lord, 7, who verify all documents of beneficiary house before payment of detailed report? 80, GP official verified the documents and propose for sanction and disbursement. Here, my lord, money disbursement is not the problem, my lord. Only it was allotted to some other beneficiary because the reason, my lord, because of those Gram Sabha resolutions, my lord. If they sent it, my lord, can you protect me in the interim and find out if the case there, my lord, with all respect, my lord, as to whether any material is against me.
Yes, Mr.
The Gram Sabha taken decision, that is all right, but overall, my lord, the video is under control video.
There is a check, my lord, but accredited engineer verifies, my lord. List I cannot change. And there is, it is not that, my lord, job has not been completed. That is not the case.
If you are in charge,
Yes, yes, my lord.
who says that you cannot change the
Yes,
list?
yes, my lord. I, no, list I cannot change. With all
List,
possibly.
list you cannot change, but it is your duty to
Yes,
ensure.
yes, my lord, some dereliction of duty maybe, my lord. But maybe, my lord, protect, my lord, if there are materials that I have done criminally, my lord, I should be, my lord, champion. Okay.
I heard Mr. B. Mahajan, Learned Council, B.K. Mahajan, Learned Council, here with the petitioner, Mr. B.V. Goy, Learned ABP for the state, the petitioner for this court has filed this ABP petition apprehending arrest in connection with an FIR dated 21/1/2023, which was initially filed before the Court of Judicial Magistrate District Morigaon and forwarded to the concerned police station. Post of the state FIR was received and registered as Hello Goody PS case number 29 of 23 under sections when so. The council with the petitioner submits that the petitioner is employed as the block development officer of Lahori Ghat. And the demands of the informant was that certain amounts were released to persons that forged the job cards of the complainants and the witnesses mentioned in the FIR, and by using the same, the name of different persons, they misappropriated government money. Most of this misappropriation is alleged in respect of construction of residential houses and the government fund. As per the Awas Plus scheme. Also, learned counsel to the petitioner submits that these allegations are not based on the report. So, in her capacity as the video, she is required to release the funds upon necessary verification of the necessary statements, showing the names of the beneficiaries by the Gram Panchayat officials. Full stop. It is submitted that the Gram Panchayat officials, by their various resolutions, decided on the names of the beneficiaries who are supposed to receive the money. And on the basis of such resolution being received and details being verified, the amounts were received, amounts were released. Most of the petitioners, the informants' names were not there. The informants were not the beneficiaries. They did not receive the money.
Can you look at page 33? The past number postal, that is in vernacular, we didn't translate it. This is the root cause, my lord.
33.
Page 33, my lord. That is in I'm sorry, my lord. Past more postal, my lord.
Yes, yes.
Read it. My lord, may I read it, my lord?
Please.
আদি গাঁও সভাই সৰ্বসন্মতিক্ৰমে আৱাজ ক্লাছৰ পূৰ্বৰ তালিকাৰ পৰা 119 জন হিতাধিকাৰীৰ নাম কাৰিকৰী ভুলৰ বাবে কৰ্তন হৈ আহিছে যদিও সেইসকল প্ৰকৃততে দুখীয়া বিপিএল পৰিয়ালৰ হোৱাৰ বাবে আদি গাঁও সভাই তেখেতসকলৰ নাম পুনৰ ঘূৰাই আনিবৰ বাবে কাৰ্যপ্ৰণালী হাতত ল'বলৈ প্ৰস্তাৱ গ্ৰহণ কৰে। So earlier of the erosion affected by those who went inside the river, my lord, in their place 190, these people were accepted, my lord. Hence the fracas. And police did not register the case immediately because, my lord, they went to court and thereafter this was registered, my lord. And I was asked to appear, I appeared.
It is submitted that as per the resolution adopted by the Gram Panchayat, the names of these persons were included as beneficiaries. Most of the Gram Panchayat has taken a decision in its meeting held on 3/1/2023, and the resolution number 5 in the same minutes is relevant for the purposes of this case. First of all, it comes into the petitioner submits that the petitioner had already appeared before the IO. You had appeared before the IO?
Yes, sir.
Statements have already been recorded, and therefore there is no necessity for custodial detention any further. Custodial detention, full stop. She will cooperate with the IO during the course of the investigation. Mr. BB, the Royal and the DP submits that the CD we call for at this stage, having heard learned counsels for the parties, let CD be called for. Meanwhile, if the petitioner is arrested, she shall be released upon furnishing a bail bond of ₹30,000 with one local CDT or like amount to the satisfaction of the arresting authority. And subject to the following conditions, petitioner will appear before the IO within 10 days from today and continue to appear on every such date as required till completion of the investigation. Petitioner will not hamper or tamper with any of the information, evidence. Petitioner will not intimidate or influence, attempt to influence any person connected with the case. And the petitioner will not move out of the jurisdiction of Iloguri PS without written permission of the IU. If any of the conditions are found to be violated, IU is at liberty to pray for recall of the interim bail granted based on 11 August.
Item 22.
Yes, Mr.
In this case, my lord, the litigation, my lord, is against the, my lord, the accused number 1. Page, my lord, the 8, my lord, FIR, my lord, starts, my lord. And the legal portion, my lord, the page 9, my lord. Here, my lord, the it says, my lord, the accused number 1, my lord, he inflicted 1 blow. And other accused person, my lord, the assaulted other person. But that victim was not, my lord, assaulted by other than accused number 1. This the specific area. And prisoner's name is, my lord, is but last, my lord, he is serial number 7. Hearing he will cry. Other people of community came in, my mother-in-law tried to prevent quarrel. Then the accused number 1 inflicted blow with big iron rod on the head of my mother-in-law and accused serious, most serious injury. Here the other accused person by assaulting my other family members for taking not the alternative to it came to the ashram to get taken according to police and the Kalinagar hospital for treatment. Having seen mother-in-law and other injured family members who were sent to for better treatment in the night of.
Yes, heard learned counsel for parties. So what is your name?
Nasir.
Nasiruddin. And
Number 7 in the affair.
number 7 in the FIR. Let us call for the CD along with the PM report. First. Somebody expired here. Person died. Heard learned counsels for the parties. Let CD be called for along with PM report. List on. It's coming from which place? Hailakandi. 22nd?
Yes.
22nd June.
25.
Yes,
Police
report.
My lord, instead of report, my lord, they send the diary, my lord. The diary, my lord, shows that,
No, are they sending a report or not?
yes, Jim of the vacancies. The report is required, my lord.
Uh,
Here, full report may not be enclosed in the diary, my lord. Here says that, case in initial stage, my lord, so at this step should not be released.
No, there is a specific orders calling for the police report.
Yes, yes.
Call it, or we'll have to call the IO himself.
Lordship, the vehicle is been in custody since August 2022. Till now, Lordship, the case is at initial stage. That's what a case diary. There can't be, Lordship, because already more than about 1 year is about to be passed.
So this is under kettle.
Yes, Lordship.
Then should it not go before the special bench?
And it's criminal petition, but not criminal.
Huh?
Criminal petition, not.
But special bench, special act.
Special action there.
What is the
Actually, my
Sorry?
lord, bail matters are only divided.
only bail?
Only bail, only bail.
Okay. Just verify and tell us. Huh? Oh.
Effective
You call for the police report immediately or we are passing orders. You
Lordship, kindly fix it on Thursday this week, Lordship, because it's a
Thursday, no, we can have it on 13th
13.
June.
13.
List on 13 June and everything the learned APP to call for the police report is directed. This is the last opportunity granted purely in the interest of justice, failing which on the next day appropriate orders may be passed by this court. Mr. Bora IPS for the petition. fixed on 13 June.
Then hearing item 45.
Diary notice.
It is submitted by Mr. P.B. Gogoi that CD call for has not been received. Although none appeals for the petitioner, the receipt that earlier order dated 12/4/2023, petitioner has been granted interim bail list again on 14th August. Only proceeding.
46.
It is not received, madam. That, hearing it for time.
Second bail petition. Is it a second bail petition?
No, my lord. It is second date when it's.
Oh, second date.
My lord, FIR is 11, my lord, SMS. My lord, may I read, my lord?
Today daily notice.
Let CD along with statement of the victim under section 164. And we call for. It is coming from Satgaon.
Satgaon, Guwahati.
Reading, my lord, it is maybe
Let it be on 13 June,
maybe 9, my lord.
9, all right, 9.
9 it is difficult, madam. Because of, I was seeking time, madam, here,
No, why is he seeking time? We are only calling for the case diary. Whatever is there is there.
The state case diary could not be produced today because I am busy with law and order duty in connection with that is matter.
Maybe 9, my lord.
Let it be on 13th. We are giving him a little more time. 13th June. It is submitted by learned ABB that CD call for has not been received accordingly. Let the matter be listed again on 13th June. Calling for CD along with statement of the victim under 164 CRPC. Mr. Chaudhary.
Yeah.
A.S. Chaudhary appears for the petition.
Supplementary list. Then hearing item 53.
Yes,
My lord, in this case, my lord, LCR was called, my lord, it can be under, I think,
not been received.
we received, my lord,
No. LCR notice. I see.
See, type 6.
Because that was not
It has come. Where is the FI?
that my lord, page 11. SMS version, my lord, as they at page 14.
Yes, please you.
Page
Yes.
11, my lord.
No, 14.
14. মহাশয় এজাহাৰৰ বিৱৰণ এই যে এজাহাৰকাৰী এজনী বিবাহিতা ছোৱালী হয় এজাহাৰকাৰীৰ আজিৰ পৰা প্ৰায় 3 বছৰমান আগতে মহম্মদপুৰ গাঁৱৰ আব্দুল মজিদৰ লগত বিয়া হয় এজাহাৰকাৰীয়ে নিজৰ স্বামী গৃহৰ পৰা মহম্মদপুৰত থকা নিজৰ পিতৃ বজলুৰ ৰহমানৰ ঘৰত নাই খাবলৈ আহে আৰু যোৱা 25/1/2019 তাৰিখে এজাহাৰকাৰীৰ পিতৃ মাতৃৰ কামৰ বাবে ঘৰৰ পৰা ওলাই যোৱাৰ পিছত আসামীজনে দিনৰ 1মান বজাত ঘৰত কোনো নথকাৰ সুযোগ গ্ৰহণ কৰি এজাহাৰকাৰীৰ পিতৃগৃহত সোমাই এজাহাৰকাৰীক ঘৰত অকলশৰীয়াভাৱে পাই এজাহাৰকাৰীক মুখত কোপা মাৰি ধৰি তাইক বিচনাত বগৰাই পেলাই তাইৰ ইচ্ছাৰ বিৰুদ্ধে জোৰপূৰ্বকভাৱে ধৰ্ষণ কৰি মুমূৰ্ষু অৱস্থাত কৰি পেলাই থৈ যায় এজাহাৰকাৰী আসামীজনে জোৰপূৰ্বকভাৱে ধৰ্ষণ কৰাৰ পিছত এজাহাৰকাৰীয়ে সমস্ত ঘটনা সংযোগে নিজৰ স্বামী আব্দুল মজিদক বিবৰি কয় আৰু এজাহাৰকাৰীৰ স্বামীয়ে ঘটনাস্থলীত উপস্থিত হৈ নিজৰ স্ত্ৰী এজাহাৰকাৰীক অতি বিমৰ্ষ অৱস্থাত দেখা পায় আৰু আসামীৰ কাৰ্যত হতভম্ব হৈ পৰে এজাহাৰকাৰীয়ে পিছত পিতৃ ফজলুৰ ৰহমানক আৰু মাতৃ তাৰাখানক ঘৰলৈ ঘূৰি অহাৰ পিছত আসামীজনে এজাহাৰকাৰীক ধৰ্ষণ কৰাৰ বিষয়ে জনায় এজাহাৰকাৰী
তাই স্বামীয়ে আসামিজনক এই জঘন্য কাৰ্যৰ বিষয়ে সোধাত আসামিজনে এজাহাৰকাৰীক দায়ী স্বামী কাৰো ওচৰত আসামীৰ কাৰ্যৰ বিষয়ে কবলৈ আৰু কেছ আদি দায়েৰ কৰিবলৈ অতি দুৰ্ধৰ্ষ আৰু বলিয়াল আসামিজনে এজাহাৰকাৰী ও তাইৰ স্বামীক হত্যা কৰি গোপন কৰিছে বুলি ভাবুকি প্ৰদান কৰে। আসামীৰ কাৰ্যত এজাহাৰকাৰী ও তাইৰ স্বামীয়ে পাৰিবাৰিক ও মানসিকভাৱে ভাগি পৰিছে ঘটনাৰ সাক্ষীয়ে জানে ও প্ৰমাণ কৰি this এজাহাৰ মানত in this case after the occurrence the victim and with her husband approached the accused why he committed such kind of heinous offense and that ezahar also filed after 1 week and thereafter my lord compromise was executed that is case 16 my lord. 16 in bottom my lord para 2 the said case it is in the compromise my lord the said case is compromised between the parties and the first party had filed the said case wrongly against the second party on the instigation of other person. It is stated now. And in the subsequent manner also, the victim denied to medically examine person. And in that case, my lord, someone is issued to the petitioner, my lord, for appearance for facing trial. The petitioner is ready to facing trial, my lord. Just as the allegation is serious, so my lord, he may be kept behind the bar, my lord. So that is why it is necessary to protect. This, my lord, in the Saksi, is 27, my lord.
How can there be a compromise of this nature?
My lord,
Can there be a compromise?
it is not compromise, but
Then?
in presence of the villager.
It is one thing for the informant to say that I am not pursuing it, but that by itself will it absolve you of your crime in the event you are guilty of committing it? It is a crime against the society,
My lord,
not as such against the person. Yes, charge sheet.
Saksi, my lord, assigned version at page 27, my lord.
Hmm.
Second line, second line from middle person. ডাক্তার দ্বারা চিকিৎসা স্বাস্থ্য পরীক্ষা করার বাবে অস্বীকার করে। Subsequently, my lord, after receiving the summons, he approached before the session work for paying bail. That was rejected, my lord. That is at this 28.
This is the second bail petition.
No, my lord. Sure, sir. It is session rejected. It is the first time. And the next date is 6, my lord, 7/6 of 2023, my lord.
For appearance. Yes, Mr. Gogoi.
Lordship, this is not compoundable offense, my lord. And moreover, case of 2019, now 2023. This, my lord, trial stage, my lord, for trial, someone is issued, my lord.
You appear.
Yes, my lord, he will appear, my lord, but in his appear, my lord, he may be taken into custody, my lord.
Maybe you will be taken into custody in the face of such. You have not filed a criminal petition saying that this should be quashed because of the compromise arrived at. There is no criminal petition pending. Then on the face of this, there is an allegation. It appears, perhaps, that you have managed to extract a compromise from the victim?
That is my lord,
Appears.
my lord.
Appears.
It was on the,
Unless you want to expand on your case to suggest why the informant will lodge such a specific FIR against you, making all these allegations.
my lord, that is there, my lord, it is stated. that-
Once it is there,
My lord,
once assuming it is there,
my lord.
can it be compromised the,
As per my lord,
unless you say that no crime has been committed. There was no, these allegations are false.
it is my lord, from the information we received that there is a land dispute between the parties in the agricultural land between the family of the victim and the accused, my lord. And on that count, and it is my lord, after 7 days, my lord, the FIR is filed. 25, 1, my lord, the offense is occurred and the FIR is lost on 1st of February, my lord, after 7 days, my lord. And in the subsequent, my lord, it is also stated that the victim denied to medically examine herself. Then also, my lord, the petitioner will suffer his trial, my lord. Just he is allowed to appear and at the time of appearance, he should not be taken into the thing. That is my own submission. Any condition, my lord.
What condition can be given?
And my lord, in the FIR also it is seen, my lord. After the occurrence, the victim along with her husband approached the accused. Why he committed such kind of, which is not believable.
Yes, Mr. Gogan.
That is the point, my lord, that they have not come for quashing of the FIR, my lord. If there is defect in the FIR, my lord, they may challenge the FIR. As well as now, my lord, Chachi Chamite. But case of 376 anticipated with 19 case, my lord, now they are noting the court.
Allegations are severe.
My lord, that is there, my lord.
Then-
But what is FIR says, my lord? In that face value, my lord, in the FIR,
No, face value, FIR is just an intimation.
after committed offense
Yes.
and after suffering the heinous crime,
Hmm.
she approached again that accused person that why he committed such kind of offense. Is it believable, my lord?
No, believable, not believable is for the trial court to decide.
That is why he is ready to face trial, my lord. Thus, my lord, his
cannot-
appearance may be
We
considered.
cannot advise you what to do. But what you are asking for is not permissible in a bail application. That is all we can say. In the face of the allegations made. Charge sheet submitted.
My lord,
Where is that order of the court below? Page number 28.
yes, my lord.
Why did you not point out the agreement at that point in time before this court? Before the court, sessions court,
Yes, my lord.
there is no reference of the agreement. Perhaps it was never pointed out.
I think, my lord, that the agreement, that is not my knowledge, my lord, but
Yeah.
in the order sheet, in the order, annexure 5, that is not reflected here.
That was that agreement was produced on
No, page 28 is the order
Yes, ma'am.
by which your bail was rejected. But there is no reflection of the agreement. There is no indication whether that agreement was referred to or not referred to. Nothing.
The agreement, my lord, in my petition, my lord, agreement is an act and that is statement.
They've not understood the, go to page 28.
My lord, 28.
This is the order by which your earlier bail was rejected.
FIR on 25/1/2019 at about 1 p.m. taking an advantage of absence of her.
No, I'm not asking you to read it. What I'm saying is, by this, your earlier bail was rejected. If you read the order, you do not find any reference to the agreement. It is your case that there was an agreement, compromise. But this order does not reflect anything. Was it placed? Was it not placed?
My lord, it is just rejected, my lord.
Well,
Not stated elaborately, my lord. In the order.
no, you don't find it conducive to grant you bail.
My lord, after market also,
No, after charge sheet we can do, that's not the issue, but the facts of the case are not in your favor. It does not persuade the court to accept your prayer for grant of bail on the basis of the allegations made. You think over, we post it after 2 weeks. After 2 weeks. Meanwhile, you can go through the scan copies also, if you want. At the request of learned counsel for the petition, the matter is deferred till for another 2 weeks.
in the meantime, this appearance may be. This appearance may be.
Nothing.
On 7/6, my lord.
If we give, we give. If we don't give, we don't give. On the facts of this case, not possible.
All right.
For orders, item 47.
Will be granted? Oh,
So, Mr. Kandi, notification was informed.
it is submitted by Mr.
Yes, Dr.
S.
Yes, Dr.
S. Bathari, learned counsel for the petitioner that the. Was there no stay earlier? Was there a stay order? It is submitted by Mr. S. Bathari that the petitioner has been acquitted. By which court?
St. Universe, Kambu.
By the court of CJM Kambu. In the case of in GR case number 6988 of 2012 under section 279-338-427. Also, do you have a copy of the order? You have a copy of the order? Give us a copy of the order. Okay, yes. The CJM court. By the order dated 12/4/2022. Did not find the accused guilty in the said case and therefore acquitted him of all charges. and set him at liberty. Full stop. He therefore submits that he does not wish to press the criminal petition any further. Criminal petition number so and so is accordingly dismissed as not pressed. Copy of the order submitted by the learned counsel for the petitioner is kept in the case record. Mr. B. Sharma appears for the state.
48.
Make this project. CD was called for that.
My lord, CD extra information I have just taken, my lord. CD is available in the office, my lord, receipt, my lord. The time it is for tomorrow or the after tomorrow, my lord. It is came in the orders column, my lord. That is our CD note, my lord, from our office, my lord.
Kindly the case may be listed for bail head
No, my lord, that.
and interim.
Matter be listed for bail hearing on
CD already received, my lord.
on 19th
My lord,
June.
19.
It is submitted that the CD be listed for bail hearing, CD to be produced on 19th June.
My
Interim order passed earlier will continue. Ms. So and so for the petitioner, Mr. B. Sharma for the state.
49.
As per office note dated 2/6/2023, service is awaited on in respect of respondent number 3. Accordingly, list after 2 weeks. The interim order passed earlier will continue. Mr. B. Sharma, your name?
Yes, yes.
S.
New.
Now appears for the petitioner, B. Sharma for the respondent. List after 2 weeks.
50.
This list on 21st. Yes. Okay. Yes.
In the positive it was shown, madam, LCR receipt. But whether service regarding the respondent number 2, madam. Completed on
Service awaited
madam.
on respondent number 2 as per
Right.
office note 26/2023. LCR isn't. LCR call for has been received in the meantime, list after 2 weeks. Interim order for surgery will continue.
51. Come on.
Yes.
Maybe, my lord, in this case, suppose the argument with Malad Council, I agree. We attend to court part of suddenly, my lord, some personal difficulty every court. So, next, any day, my lord.
He must have been scared of the council for the other side.
My lord, actually, my lord, his, no, he didn't inform regarding such problem.
Very small matter with regard to the punishment that was given to.
Ali is not available with me.
I'll just make a, okay, I'm not arguing that, just making a mention about what exactly is the case. Whether a person who has already gone through the default period. The default period, that means the fine was given and in default, he has to go for a imprisonment for another 2 months or so. And he has also already completed that default period also. Now, whether the court, whether the application under 421, which was made before the court, is applicable again for payment of the fine. That is basically the case here. I have a judgment exactly on the same issue. They are not facing because he's not there. So that is the only issue here also, whether he is entitled, whether the petitioner is again entitled to go through the same procedure again with regard to the fine and the compensation.
No, it is submitted by Mr. Learned counsel for the respondent, that the arguing counsel, Mr. I. Hazarika, appearing on behalf of respondent number 2.
One, sir.
1.
Sole respondent.
Sole respondent is not available in court. Had to leave court because of personal reasons. Therefore, he seeks an adjournment in the matter. Mr. Y. S. Mannan, learned counsel appearing for the petitioner, submits does not object to the prayer made, as the same is on his personal account. On personal ground, least again.
Any get my lord.
15th.
This one.